Thank you. So this is a project which Karan and I have been working on for some time. And as the last speaker pointed out, there is a problem of delays in India, and there are many attempts being taken at computerization, time tracking, and things like that to ensure that uh, that delay is resolved. Karan and I probably think that there is some deeper problem which leads to judicial delays, and it may be related to incentives. Uh, so India has now got a slow judiciary, and there is one of the reasons for that is frequent adjournments. Roughly half to two-thirds of cases, any hearing on an Indian court is usually an adjournment. So that rarely anything moves on those. So the question we wanted to ask was, is there a frequent reason for so many adjournments in Indian courts today? And one of the things we looked at was the interest rates that courts awards to the successful party. Uh, in any litigation, which is about recovering some amount of money, and almost all contract disputes and even say disputes for pay or disputes for property can be distilled into a money value. There are two costs, which is the cost of the litigation and the interest on the money that is being paid, claimed by the petitioner. And if the interest rate is too low, then the defendant has an incentive to delay the litigation. So assume that I violate a law and I have to pay 100 rupees to somebody. And the court awards an interest rate, say 5%, while in reality, the cost of money for me to borrow from the market is 10%. Every year I delay the case, I make 5 rupees free money. This is the opportunity cost of me paying up today to the plaintiff and finishing the case rather than delaying the case. So this 5 rupees is money I make every year. And if I can delay the case over 20 years, I have actually made off the 100 rupees I have to pay upfront in this. In a simple interest calculation, in a compound interest, it will be even shorter. Now, how are interest rates awarded globally? Roughly, there are 4 ways in which interest rates can be awarded. One is you leave it to the judicial discretion of the judge, that the judge decides what happens. The other is an economic calculation of the cost of capital or the time value of money for the parties and then giving that money. The third, if there is a contract between parties that have agreed to a rate, then awarding that rate. And finally, you could have something like a reference rate set in statute, which can be used to pay the amount of money that is required. This is a comparison of India's rates with other countries, and more importantly, it compares the rate of that will be awarded in a judgment with what is the risk-free rate in that country. So that's the rate at which you would get money if you had kept that money in a safe government investment or a nationalized bank. And this is the rate which is set in the statute, which is usually in the Code of Civil Procedure. In India, you get there is a separation between commercial and non-commercial cases. In commercial cases, you get 8.76% now, and in non-commercial cases, you get 6%. The risk-free rate, on the other hand, which is the most safe investment rate you would get, is we took it around 7.13% when we wrote the paper. And if you notice, for non-commercial cases, the rate is even lower than the risk-free rate. That means the highest rated borrower, which certainly is not most defendants, can get it at a lower rate from the market. So every year, say the government of India is a defendant, and the government of India has to pay private citizen some money. If the government of India can delay the case, every year the government makes 1.13% interest, free money. And I assure you, none of us can borrow at 7.13% roughly. You would be borrowing at 16-18% interest rate. And at that interest rate, you're making so much more money on that system. In contrast, look at United Kingdom, where the difference is 7.82%. So the risk-free rate that time was around 0.93. It has gone up now. but the interest rate awarded in statute is 8.75%. California had a 10% interest rate awarded in the statute, while the risk-free rate was 2.25%. In those countries or in those jurisdictions, you make a lot more less money by doing this, and roughly even commercial borrowers' interest rates would be much lower. It would not be covered by something like an 8.5 or 10% interest. So in those countries, it makes sense for a defendant to quickly settle the case because the judgment awarded money will be much higher than what they could make off the market or the opportunity cost of money. The other problem that has happened in India has been a huge difference between different rates. So at different points in time, there has been different laws which have made different sets of rates. So the Code of Civil Procedure, which should be the general law in India, pays you 6% for a non-commercial case and an 8.76% for commercial cases. Negotiable instruments law gives you 18%, which may explain a lot of reasons why cases in India, the courts are flooded with negotiable instruments law cases rather than commercial disputes. Because if you're in a commercial dispute, you will get only 8%, while if you can convert it into a negotiable instruments case by taking some post-dated check, you get 3x the return from that amount of money. Then there was another law, which is the MSMED Act in 2007, 2005, which for medium, small, and enterprises, the rate is 20.25%. There is another Interest Act, which is supposed to cover interest before, during the pendency of the case, that pays around 10%. So not only do we have low interest rates, and we have a variety of interest rates which would distort the incentive of parties to file cases under various laws and try to think about how to go and delay the cases. The rate for the 6% rate in CPC was fixed in the Civil Procedure Code was fixed in 1956. They haven't changed, and bank rates have been higher than the statutory rate since 1971. So this graph draws the bank prime rate in India, and why the dotted line shows the 6% limit. So if you notice that since 1970s, the bank rate has been, the safest investment rate has been much higher than what you would get if you were just to pay out as the civil procedure case would require. So it makes absolutely no sense for parties in some ways to pay out or finish a case, even if they know that they are going to lose. Because every day the delay can be made, they are making free money of the system. As a consequence of this could be that we get this judicial delays, and we also get a reduced certainty in contracting because we have two different rates. Courts sometimes don't even award those interest rates. We get into a non-standard set of rates, which creates this incentive to put this system. One case which kind of acts as a nice exemplar is this case of Vedanta versus Shenzhen Shandong Company. This was an arbitration. The arbitrator awarded some interest rates. Shenzhen Shandong had sued Vedanta, and then Vedanta took this case to the Supreme Court, and the case got delayed in the Supreme Court. Shenzhen had won the case against Vedanta in the arbitrator. So Vedanta entered into a contract to construct a power plant. The power plant never came up, and Shenzhen was supposed to provide some machinery to Vedanta, and the case was disputed. Arbitrator awarded the case in international arbitration for two components, which is the rupee component of the award and a euro component of the award. And it set the rate at 9%, but it put a clause that if Vedanta failed to pay in 120 days, Shenzhen was entitled to a higher rate of 15%. The Supreme Court took some time to reduce the case and to decide the case and reduce the interest rate to 9% on the rupee component and only 2.62% on the euro component. Again, by looking at the reference rate in euro, but not considering the fact that the risk of the borrower or the defaulter is actually what determines the interest rate. And what we found out was very interestingly that if during this period when the judgment came out, Vedanta actually had to do a debt raising. So they went out and borrowed money from the market, from the London market, and they also did some borrowing at the domestic market. At that, it's quite interesting that it had to pay 8.75% interest rate on its euro component borrowing, and it had to pay a 15% interest rates on its rupee component. On the other hand, for rupee component, the Supreme Court awarded the rate of 9%. So it's a clear 6% difference, and similarly another 6% difference on the euro component. So Vedanta provides a natural experiment because it went to the market and borrowed at the time of the judgment. So we can look what is the interest rate. So effectively, the judgment rate that the Supreme Court awarded was lower than the rate at which Vedanta could borrow from the market. So this is giving money to Vedanta, free money every year. The Vedanta delayed the case. So every year Vedanta delays the case, it gets the difference in the interest rate multiplied by the initial award of the amount, which is the rupee and the euro component. So using this, we can calculate the kind of money that they saved. So Vedanta saved by putting up the case. So if the case took around 7 years to decide in the Supreme Court, we could look at the cost of borrowing for Vedanta, and we could look at the cost Supreme Court awarded interest rates. And we found out that if the case took 7 years, then the Vedanta made 262 million rupees and 10 million euro in savings by delaying the case for 7 years. If the case went up to a longer time, 11 years, it would have made so much more. 15 years, it would have made 561 million rupees in rupee saving of the component of the award, and $21 million in euros in the system. So the Vedanta experiment, natural experiment, shows a very interesting insight that the delay actually makes money. And it may also explain the high fees that lawyers are able to charge in the Supreme Court in India, which sometimes shocks external observers. Because this is a kind of money that cannot be generated in any of the other courts where the interest rate awarded would be much higher than the cost of. So the Indian system has created 3 levels of uncertainty because of this: whether the interest will be actually awarded or not, whether the interest will be awarded as per the arrangement of parties, or if not, what is the rate at which interest will be awarded by them. And most of the time, we have seen that court emphasize on discretion in award interest. Even when parties have agreed to interest rates in the contract, courts overrule those contracts and do not award those interest rates. When courts change reasoning, they say some just things like, oh, the rate is too high or too usurious, like they did it for the case of the Vedanta, but there was no economic reasoning whether it was too high or not. In fact, we could see that the rate that the arbitrator awarded in the original case was much closer to what the actual borrowing costs of Vedanta were compared to what the Supreme Court. What's the way forward to this? We need to consolidate the laws of interest across various laws in India. If parties have agreed to a rate between them for disputes, that should be given primacy over others. And this should match, and there should be an updating rate for all damages, which needs to be updated every year based on some economic activity on the average cost of capital of India. So this is the simple solution to go. If there's a contract rate, apply that. If there is no contract between the parties, like a tort or the parties didn't agree, we have to go to some cost of borrowing of the parties and come up with some effective economic interest reference rate to do it. But that has to be high enough to discourage parties litigating. Thank you. I'm done for the presentation. I'm happy to take any questions.